Hi, everyone. Welcome to our second session webinar of the Animal Legal Defense Fund's Animal Law Summer School. Sorry, a little tongue-tied. This year, we are focusing on all things factory farming and farmed animals. And with me today is David Rosengard, staff attorney of the Animal Legal Defense Fund, talking about criminal prosecution of farmed animal abuse and neglect cases. Like always, my name is Priscilla Rader. I'm the education coordinator for the Animal Legal Defense Fund, and this is part of our Animal Law Academy webinar series. And we're so grateful that you're able to join us today. And we will be doing Q&A after this webinar. So it will be about an hour long, and then we'll jump right into Q&A and try to get through as many of your questions as possible. You can use the sidebar questions part on the webinar platform, and just feel free to ask your questions as soon as they pop into your head. You don't have to wait until the end, and we will try to get through as many as possible. We also have a handout under the handout section of that sidebar. That is the PDF of the slideshow. So if you wanted to follow along at home or use for reference later, you can download that. We can also get it to you later if you want to email me at prader@aldf.org. If you're unable to download that, or if you're viewing this at a later time, happy to get that PDF to you. Otherwise, I'm very, very pleased to have this presenter today, David Rosengard. Like I mentioned, he's a staff attorney for the Animal Legal Defense Fund. He's a graduate of Lewis and Clark Law School and also received his LLM in animal law at the same school. And he's done a lot with farm animals and animals as victims in the criminal justice system. So I'm very excited to hear from him today. And like I said, Q&A after, but feel free to ask those questions as soon as they pop into your head. And we can also do clarification questions throughout the webinar. So if you do need any point of clarification, please do just let me know, and I'm happy to ask David. But otherwise, I will turn it over to him and get started. Thank you so much, and please join me in welcoming David.
Hello. Excellent. Well, it's good to well, not see you because I can't see you, but it's good to be seen by you, however, telephonically. And as Priscilla said, I'll be doing about an hour of discussing how we can apply animal cruelty law to benefit farmed animals, how we can use that on their behalf. And certainly as I do this, I'll try not to let my enthusiasm for the subject carry me too far away, but if we are straying into an area where you're getting lost, just say something, Priscilla, we'll get it sorted out even before we get to the Q&A at the end, and we will certainly have time for questions at the end. So that said, we'll go ahead and start. See if I can get this to advance appropriately. Excellent, that seems to be working. Wonderful. Yes, I hear from Priscilla that it is. That is great news. So let's start with some overview and some context. And one of the things that I'd like to do during this session with you is dispel some myths around farmed animals and animal protection, animal cruelty law, because they exist in a variety of contexts coming from a variety of directions. So one of the myths that we'll be tackling is that applying the law to farmed animals is somehow new. And in the context of the law, we often hear new as code for fringe or radical or scary. And we'll be discussing how that really isn't the case, how in fact applying the law to farmed animals is anything but new, anything but fringe, and anything but scary. We'll be talking about the notion that there are certain types of cruelty that don't happen to farmed animals. In popular culture, we often talk about farmed animal cruelty in very specific ways, and that often excludes certain kinds of cruelty from conversation. And I'd like us to have this opportunity to break that down a bit and unpack that notion. And then finally, one of the chief myths we'll be dealing with is this idea that animal cruelty law cannot protect farmed animals. There are reasons why we've heard that. We'll talk about what some of those reasons are, but we will also talk about how we can use the law to actually protect farmed animals and how we can improve the way the law does that. So moving from myth, we'll embrace some realities. We're going to look at who we're talking about, who the animals are. We'll talk about implicated laws and conduct. And so by that, I mean both which areas of law we're dealing with at a federal, at a state level, but also what kind of conduct is actually implicated by that. So what the criminal activity that we'd be looking at in this context actually might be. And then we'll spend a little bit of time talking about closely related criminal issues. So non-criminal law that connects to this larger topic of farmed animals and how we can use the law on their behalf to protect their interests. And then finally, we'll talk about what you can do with all of this, whether you are a legal practitioner, whether you're a member of the general public, and then a big part of what you can do with it is answering the questions that you have. And that's the part that honestly I'm looking forward to in some ways the most, because, well, if nothing else, I know what I'm going to be talking about for the next 45 minutes or so, and it's much more exciting for me to hear what you would like to talk about and what questions you have. So before we move on, though, I want to give a note on images. There are, as you can imagine, a bevy of very disturbing images related to the conditions that animals are in industrialized agriculture, and in particular, the conditions that animals who are experiencing cruelty find themselves in. I'm not going to be showing you the worst of those images, and I'm not going to be doing that for a few reasons. One, I realize that for many of you, it may be your lunch hour, and I don't want you to be unable to eat and therefore lose focus on our conversation. Two, even if it's not your lunch hour, these can be disturbing images to look at, and again, may cause you to disengage from the conversation. And three, these are not hard images to find. You can Google farmed animals, cruelty, and you will find many, many examples of that. And while I want to acknowledge that cruelty does happen, and I encourage you to become aware of that reality, and we'll talk about what some of those cruelty episodes consist of, I also want us to be present for this conversation with each other. So if you feel the need to have that experience, feel free to Google along as we go. Otherwise, if you're unfamiliar with what that's like, you can Google after the fact. And otherwise, I suspect that you've got the gist of it. And images, if you see images of animals in this presentation and they aren't part of our ALDF sidebar here, and they're not otherwise credited, those are courtesy of Joanne MacArthur and the We Animals Project, which is a great source for high quality, curated, validated images of animals in a variety of contexts that she makes available for programs just like this. So I encourage you to look that up online if you'd like to know more about that. So let's do some context, some overview. Continued. Farmed animals and the law. Is this new? No, it's not new. In fact, farmed animals have a lengthy history within the law. And historically, they're one of the first areas covered by the law. And I won't go too deep into why that is, but there's a strong argument to be made that the law as we know it today develops alongside agrarian societies, alongside societies that are transitioning from a nomadic way of existence to a more sedentary way of existence, where there's a greater need to delineate how you handle disputes within a ever-growing population. And one of those disputes in a burgeoning agrarian society concerns farmed animals and what one does with them. So in fact, this bullhead that you can see is a Mesopotamian figurine from, I believe, around 2500 BCE. And that's indicative of one of the most famous legal cases involving farmed animals that dates back to antiquity. And this is the famed bull of Exodus 21:28, which is essentially a tort case. A bull gores someone, and the question is, who is responsible? Does the owner pay? How much does the owner pay? How do we evaluate the degree that the human that was injured by that bull put themselves at risk? classic exciting torts stuff. And indeed, we see farmed animals popping up in the law throughout a lot of different areas. We see it in religious law, we see it in tort law, we see animals popping up in contract law. But there's a particular relevance for what we're talking about today in terms of the intersection of animal law and criminal law. And again, this is not a new area. The roots of the relationship between animal law and criminal law are deep, although tangled. What we think of as the way criminal law deals with animals today is not how criminal law has always dealt with animals. Today, we often think of criminal law dealing with animals from the perspective of addressing the need of animals to be kept safe, the need of animals to be protected from cruelty, from abuse, from neglect, from exploitation. And this is important, but this is not necessarily the only reason criminal law deals with animal issues, nor has it always been the historical reason that criminal law deals with animal issues. So when we're unpacking that relationship, it behooves us to look at all the different reasons that criminal law is concerned with the way that humans interact with animals. One of those reasons historically has been about property crimes. If an animal belongs to some other individual and you harm that animal, steal that animal, kill that animal, you have, in addition to the harm visited on that creature, you've also deprived that animal's owner of their property. And in a traditional criminal law analysis, that's a property crime. There's a separate thread of criminal law that looks at animal cruelty issues from the standpoint of public morality, public health. The notion here is that there's something corrosive to the public good when we allow humans to brutalize animals. In some ways, this is an early intuitive rendition of what we've later found to be borne out by a variety of sociological and psychological study, that there's a crossover between antisocial violence visited on animals and antisocial violence visited on humans. In other words, an individual who commits antisocial violence doesn't typically restrain that violence to one victim or even one category of victims. And therefore, if you're worried about the well-being of other humans, it behooves you to worry about the well-being of animals, vis-a-vis antisocial criminal animal cruelty. But even looking back at early examples of animal criminal protection, there continues to be this notion that has grown in the recent years that animals deserve protection on their own terms. That we protect animals because they are sentient creatures who can feel, who can experience, who suffer when they're hurt, who starve when they're not given food, and who don't deserve to have that visited on them by humans who have responsibility for their care and their well-being. And that is an important development in animal cruelty law. And it's important particularly as it applies to farmed animals, because that development marks the distinction between saying, we're concerned about animals when they are someone else's property, or we are concerned about animals when you're abusing them publicly, and saying we are concerned about animals overall. We're concerned about animals because they suffer. So this is the difference, for example, between a law that says you cannot beat someone else's horse, but you can beat your own horse. Or if someone leaves their cow or their pig in your care, it's illegal to starve that animal, but you could starve your own cow or pig or chicken whenever you'd like. This is the difference between a law that says it is a criminal offense to publicly abuse an animal, to abuse an animal in the street or in an open lot, or even on your own property, as long as it's visible to the public eye, but you can still do that behind closed doors. The modern version of animal cruelty law very much acknowledges the property position, and implicitly, I would argue, acknowledges a concern for human health and well-being, but ultimately can only be explained by realizing that it fundamentally focuses on the health and well-being of animals, and our responsibility not to subject animals that we have custody and control over to unlawful cruelty, suffering, and harm. And there are reasons why that's important beyond just the simple fact that it keeps animals safe. The use of criminal law as it intersects with animal law adds substantive and symbolic value to the two areas. For one, at the end of the day, whatever protections we want to exist for animals, criminal law is necessary to actualize the animal's legally enforceable interests. If we want animals to be protected, ultimately we need a criminal statute to say violating that protection is a crime. Because otherwise, animal protection becomes a matter of harming humans rather than harming animals. Or, best case scenario, it becomes a matter of someone being able to file a tort suit on behalf of an animal, but it doesn't allow society as a whole to intervene on that animal's behalf. Further, I would argue that the intersection between animal law and criminal law really encourages us as a society to confront the contradictions inherent in the way the law is developed around animals and grapple with the true costs of how we deal with animals. And this is to say, for example, if we want to say that certain ways of treating animals are legal and are acceptable, we can do that. But we have to acknowledge that, and we have to acknowledge that clearly and explicitly within the law, and we have to be willing to stand up and say, yes, I'm willing to have this done in my name. Yes, this degree of animal suffering is worth it. And if we're not willing to do that, and I would argue that increasingly we as a society are not willing to do that, then it is incumbent upon us to make sure that the laws reflect that growing social consensus. And if we want to continue to interact with animals in certain ways, that animals are being dealt with in ways that live up to what we've decided is our social expectation. So if, for example, if the expectation is that animals will be treated humanely, then we need to be prepared to grapple with what that actually means and what that actually implies. And finally, the intersection between animal law and cruelty law, that is between animal law and criminal law, really impels a focus on animals' experiences. So this isn't about the way the treatment of animals impacts humans. It's not about the way the treatment of animals impacts the environment. It's not even about the way the treatment of animals impacts an animal species or an animal subpopulation. It is fundamentally about the way the treatment of animals impacts individual animals, their lives and their experiences. And that's not only important for those animals, but it's important because it fundamentally sends the message that those animals matter, and they matter in a deep and ongoing fashion. We'll talk more about this when we talk about animals as crime victims, but something that I encourage you to think about when we think about criminal law is that criminal law is about more than saying this behavior is bad. It's about more than saying we don't accept this behavior. It's about more than saying your behavior hurt someone and you owe them a chance to be made whole. We have other areas of the law that can address that. If we want someone to be made whole, we can use tort law. We can similarly use tort law to address unwanted behavior, inappropriate behavior. Criminal law ultimately is about saying we as a society are speaking with a clear and unified voice to say this behavior is unacceptable, because it harms victims. And that involves recognizing the harm done to the individuals that suffer because of that criminal conduct. And so when we apply criminal law to animals, one of the things we're ultimately saying is, as a society, we recognize these animals as individuals, we recognize their lives and experiences as meaningful, and we recognize that they should be protected, and that when they are victimized, that is addressed. And I can see the speech bubble going off, so I hope that you have a great number of questions about this. And I'll pause for a moment to see if there's anything, Priscilla, that I need to clarify before moving on.
No clarifications, just a lot of amens, and you're right. So
Lovely.
keep doing
Excellent. Excellent. So let's talk about which animals are actually involved. And at this point, I'm going to talk both a bit about the statutes, although we'll get more into this shortly, but also about which animals we're talking about for the purposes of today's conversation. Because farmed animals is not a legal term. And you will find laws using many different legal terms to address the kind of animals involved. So for the purposes of our conversation today, I'd like us to focus on farmed animals as meaning animals that are captive bred for commerce, that are captive bred to make someone money. And so that is everything from fur farms, like this captive mink there, to chicken farming, whether those chickens are farmed for eggs or for their flesh, to pig farming, to aquaculture. And I know that our prior session of the Animal Law Summer Series focused on aquaculture, but it's worth noting again here because aquaculture is often something that we forget when we're talking about factory farming, and we also forget when we're talking about cruelty law. Are fish covered by cruelty law? And that answer, as we'll see shortly, depends a lot on which cruelty laws we're dealing with. This also would apply to puppy mills and other forms of intentional, intensive breeding of animals for the commercial pet trade. And there are many other examples, as we'll get to. Two areas that I'm not going to be able to cover today, even though they would fall within that captive bred for, broadly speaking, a commercial purpose definition, are animals as used in research or entertainment. And these are both important topics. They're both topics that involve a much larger separate range of statutory and regulatory issues. And I'm afraid there just is not enough time in the next 39.5 minutes to get into that. It is worth noting, however, that there's a lot of crossover in terms of which animals are involved. So you could see a pig here who's being held in a crate that looks very similar to the crate you saw in the previous slide. That crate is actually used for research purposes, and that pig will be spending the rest of her life in that enclosure, and that isn't necessarily a different environment than she would live in if she was being used for commercial breeding or commercial flesh production. However, she's being used for research, and that puts her in a whole different legal category simply because of the way humans interact with her, not because of the animal that she is. And that's something we can talk about further as we get into the details of how criminal law works. So again, we're focusing largely on, and on that farm, we have some mink, ferrets, poultry, pigs, cows, fish, dogs, horses, all kinds of animals who are bred intentionally and in captive manner for commercial use. So what laws are we dealing with? Well, there's two broad areas of law that we're looking at. There's federal law, of course, there's state law. And to run through the federal laws quickly, we'll get into a little more depth. We have the Humane Method of Slaughter Act, we have the 28-hour law, we have the Animal Welfare Act, and we have prohibitions on crush video. And then for state laws, we have 50 different versions, which in some ways is great because we have the opportunity for certain states to be pushing the envelope and doing much better work and exploring ways to protect animals in various different ways. And we can see what works better and then begin to implement that in other states. The laboratories of democracy, as we're fond of saying in the law. On the other hand, it means we have some states that lag far behind. And here you can see our latest ALDF rankings of animal protection laws between the 50 states. Green is the top of the ranking, red is the bottom. And you can see where your home state falls on that. Regardless, state laws are going to have a few commonalities. They're going to cover different kinds of conduct in different animals. They're going to be proscriptive, prescriptive, or both. And what I mean by that is the laws will either say you can't treat animals this way, or they'll say you have to treat animals that way, or they'll say both. They will lay out the elements of the crimes involved. So what kind of mental state you have to have, and what a prosecutor would have to prove in order to successfully charge and convict someone of the relevant crime. And those laws will also have explicit and implicit exemptions. Written into the law, there will be certain passages that say these kinds of things don't count as animal cruelty. And there will be other portions of the law that implicitly carve out certain kinds of behavior or certain ranges of animals as being beyond the law's ability to protect. We'll get into more of that in a moment. So let's talk about a summary of federal animal cruelty law. And we can go through this pretty quickly because it's narrow in scope and of limited enforcement. And that is not unique to animal cruelty protection. Most criminal law in America happens at a state level. It's not typically federal, even though the feds get a lot of attention and a lot of funding dollars. We can have a whole separate conversation about why that is, if you'd like. So one of the laws involved is the Humane Method of Slaughter Act that requires that animals be rendered insensible to pain prior to slaughter, or that they be slaughtered via a religious ritual that involves the instantaneous severance of their carotid artery. Now, this applies only to slaughter. So facilities where animals are bred, entirely outside these protections. Facilities where animals are fattened up prior to slaughter, entirely outside these protections. This law applies only to slaughterhouses and the moment of slaughter itself. This law is also silent on poultry. It protects cows, pigs, other livestock. But even though poultry could be included, the Secretary of Agriculture has chosen to exclude them. So the statute itself doesn't address poultry. It doesn't say whether poultry are part of the livestock category, and the Department of Agriculture, as a matter of policy, has decided not to put them within that category. The enforcement mechanisms are also, well, frankly, they're weak for the Humane Method of Slaughter Act. The chief way it's enforced is USDA inspected slaughterhouses have a USDA inspector on site. If you don't pass your inspection, you can't sell your meat commercially. And the inspectors are supposed to shut down your slaughter site, or at least the relevant portion of that site, if they find you violating the HMSA. So if you fail to instantly render an animal insensible to pain, if an animal is left to experience the pain of being slaughtered, that potential slaughter box or kill chute will be shut down until the issue is rectified. And in fact, the inspector can shut down your whole site. This is inconvenient if you're running a slaughter business. It cuts into your profit margins. It has an impact on your bottom line, but ultimately, it doesn't get at the heart of the issue, which is animals are suffering in ways the law is supposed to prevent. And it's worth noting for a moment what we mean when we talk about insensible to pain. There's a popular notion that means that animals are unconscious when they're killed. And in theory, that's what they mean. But when we dig down into how animals are rendered insensible to pain, we're talking about things like gunshot to the head, captive bolt to the head, electrocution, exposure to carbon dioxide gas. These are usually methods that we think of as killing animals. shooting an animal in the head is normally considered a way to kill an animal. For these purposes, it's also a way of rendering an animal insatiable to further pain. So when we think about what the requirements of the law are, it's worth noting that it's a law that is meant to prevent unnecessary suffering during the slaughter process, but it's also a law that explicitly grapples with the notion that animals are going to be subject to some pretty brutal treatment under the law, and that is perfectly legal per the HMSA. The 28-hour law is a law that simply deals with how animals are transported in commerce and requires that they get a break from transport roughly every 28 hours. You're supposed to take them out, unload them, let them walk around, stretch their legs, get some water. However, it's very easy to extend that 28-hour period or to entirely waive it. So this is a law that we see more in practice, more in theory than we do in practice, particularly as the network of transportation around animals has been built to take this law into account. So when you see animals being transported on the highway, they are subject to this law, but that doesn't necessarily mean they're getting out of those cages every 28 hours. They may be being waived or they may be being extended. The Animal Welfare Act is not really about farmed animals. The only relevance is really going to be breeders who are selling non-rodent mammals. And that's because as far as the AWA is concerned, mice and rats don't count as animals. They are something else. They are not animals for AWA purposes, but this does mean for what are colloquially known as puppy mills or cat mills, there is a requirement that they be licensed and that you can't be licensed without a successful inspection from the Ag Department. Again, this works rather like HMSA inspection insofar as if you don't pass your inspection, you can't sell those animals in commerce. So it impacts your bottom line, but it doesn't necessarily expose you to a sort of sanction that would speak to the fundamental suffering that animals may be experiencing in a breeding operation that isn't providing them with sufficient food, water, shelter, enrichment, and so forth. There are, of course, prohibitions on animal fighting, and we see this often with farmed animals vis-a-vis fighting roosters. It is illegal as a matter of federal law to have birds and mammals fight each other. As a federal issue, that has to involve some sort of interstate commerce component, but at this point, that's pretty easy to reach. People involved in animal fighting are typically communicating through phone lines or over the internet, or moving their animals around in interstate commerce. It's a fairly easy to reach element to prove, and we can therefore fairly safely say that animal fighting is illegal as a matter of federal law. And finally, crushed videos. That is effectively an animal snuff video where animals are killed on film for the sexual gratification of viewers, is largely illegal. It's illegal to produce or distribute those when the behavior depicted is obscene and involves the serious bodily injury of mammals, birds, reptiles, or amphibians. I won't get further into that at great detail. If you have questions, I am happy to talk about that at length. There's some fascinating First Amendment law, but the takeaway for farmed animals is historically, people have used farmed animals in these animal snuff films. Baby chickens, baby rabbits are frequent targets, and those are both protected under the law currently, at least as it applies to producing the video. There is an attempt currently in Congress to make the underlying behavior illegal. That hasn't yet succeeded. As a matter of federal law, as we'll see, that behavior might be illegal as a matter of state law. So let's take a look at states. Again, I'll pause briefly to see if there are any clarification issues. He said, sneakingly giving him a moment to recaffeinate and rehydrate.
None right now. We are good.
Great.
Yep.
So I can't get into all 50 states, but I am going to give you a summary from one of our top tier states, one of our medium tier states, and one of our bottom tier states. That's going to be Oregon, Arkansas, and South Carolina. And I can't even get into all of the intricacies of each of those states' cruelty laws, because I could do a full hour session on each of those. But I will do a summary of some key points. So the first is, in a given state, who counts as an animal for that state's animal protection law? So you can see in Oregon, birds, reptiles, amphibians, fish, and non-human mammals all count as animals. In Arkansas, vertebrate animals except fish count. And in South Carolina, it's vertebrate animals except poultry. So if you are a fish being abused, if you are a bird being abused in either of those two states, I have bad news for you. The rest of what I'm going to talk about simply does not apply to you, because those states have decided that as a matter of law, you don't count as an animal for cruelty protections. Those states also define what constitutes abuse under the law. And again, I'm summarizing and condensing here, but in general, in Oregon, abuse is causing physical injury to an animal or cruel death. And depending on how bad the abuse is, it might be animal abuse 1, it might be animal abuse 2, but in general, physical injury or cruel death. In Arkansas, it's unjustifiable pain or suffering. And in South Carolina, it's unnecessary pain or suffering. Let those phrases sink into your head a bit. We'll be coming back to some key points in those and how they operate to protect or not protect animals is in a moment. As far as neglect goes, in Oregon, that's failure to provide minimum care to an animal or tethering an animal in a way that results in serious injury or death. In Arkansas, we're talking about failure to supply sufficient food and water or adequate shelter. And in South Carolina, it's deprivation of necessary sustenance or shelter. So again, particularly for those of you law students watching, there's some issue spotting here. Channel your inner final exam taking law student and think about what that phrasing implies. We'll talk about the answers in a moment. Unlike actual law school, I will not make you wait until the end of the semester to find out what is going on. Animal fighting is illegal at the state level, as it is in every state. In Oregon, it's a racketeering eligible crime. It triggers organized crime law, in other words, and lawful hunting is exempt. In Arkansas, lawful hunting or training an animal to engage in lawful hunting is exempt. So if you have a hunting dog that you're training to hunt, that doesn't count as animal fighting. And South Carolina is similar, with the addition that hog dog rodeos don't count as animal fighting. And for those of you who have not had the dubious pleasure of looking into those, hog dog rodeos are an event where a pig is released in a arena. This is typically a wild hog, a feral hog, and dogs are released to corner or wrestle with the pig. These are presented as competitions of the animals, of the dog's skill. In theory, the dogs don't maul the pigs. In practice, the dogs are attempting to herd pigs and often grab them, and dogs don't have opposable thumbs, so that grabbing often involves their doggy mouths. Again, be happy to talk at length about whether that does or does not implicate certain animal fighting issues. Animal mills are regulated in Oregon as far as dogs go, insofar as there are regulations on the number of breeding dogs you can have, the kind of care they need to get, the environment they have, and people with a certain threshold, a certain number of breeding dogs are subject to administrative inspections, which from a criminal law perspective is exciting because it means that you have someone from the government regularly going in and looking at the conditions these animals live in, and you can do that without a search warrant. It's an administrative search. There is no equivalent law in either of the other two states we're looking at, although it is important to realize that all the rest of the laws that we're talking about still apply to animals in commercial breeding operations. So if you've got a cat mill, even though it's not regulated in any of these 3 states, laws on neglect or abuse still apply. Now, as far as explicit exemptions go, in Oregon, good animal husbandry practices are explicitly exempt. If you are engaging in a good animal husbandry practice, whatever you are doing, whatever that practice is, does not count as animal cruelty. And if you are engaged in a rodeo, if you're raising commercial poultry, if you're engaged in a lawful slaughter activity, anything you're doing is not animal cruelty unless you are exhibiting gross negligence. So you don't get a free pass for rodeos, commercial poultry, or lawful slaughter, but you have to be pretty negligent to lose your exemption. In Arkansas, anything that is generally accepted animal husbandry or an animal competition, rodeo, dog show, that kind of thing, is exempt, as are lawful slaughter activities. And in South Carolina, agricultural practices writ large are exempt, as are episodes of accepted animal husbandry. So let that sink in for a moment. And let's talk about what some of these exemptions mean. As far as the explicit exemptions, you may be asking yourself, so what is good animal husbandry? What is generally accepted animal husbandry? How do we find this out? And you may be thinking, I will turn to my statute book, or I will Google good or accepted animal husbandry, and surely there will be a definition. You will be disappointed. You will find many definitions if you Google what this means, but there is very rarely a statutory definition of good animal husbandry or generally accepted animal husbandry. Occasionally, you'll find exceptions to that rule, and there'll be some discussion in the statute of how you would arrive at knowing what this means. But largely, this is left up to whoever the jury would be in a criminal trial. And there's also a subtle distinction in the way this is phrased. So good animal husbandry doesn't mean every type of animal husbandry. It's not every way you would raise an animal. It doesn't even mean common ways you might raise an animal. It means the good ones. So ways that meet an industry or a veterinary best practice, ways that would be approved of by professionals in the field. The sort of behavior that you could probably find a well-respected expert to come and testify on behalf of. In contrast, generally accepted may just mean popular. A lot of people treat their animals this way. A lot of people raise their cows, their pigs, their poultry in this fashion. And agricultural practices has no such proviso at all. So agricultural practices doesn't require a commonality or a best practice approach. Are you raising fish in an aquaculture installation? Are you raising hogs? Are you raising poultry? Is this agriculture? Great. In South Carolina, you are exempt. Beyond those explicit exemptions, there are certain implicit exemptions that it's worth thinking through. Because while not every state has explicit exemptions, every state does have these implicit exemptions, or what I like to think of as shadow exemptions. And they really have to, because otherwise the animal husbandry industry, the animal slaughter industry, the industry of using animals as food products in those states would be per se illegal. So when we look at the definitions, for example, of abuse in Arkansas or South Carolina, we find that in order to be abuse, conduct, the behavior that the human is engaged in has to be unjustifiable or unnecessary. Again, what does unjustifiable, what does unnecessary mean? That's going to be up largely to a jury. And there's a fair amount of difference between those two terms. Humans Well, we are pretty clever creatures. We can justify a lot of behavior. Necessary, I would argue, is a higher bar. It's harder to say something is necessary in order to achieve an end goal. So if the argument is that one is raising pigs ultimately for slaughter, yes, it's necessary that those pigs die. That's the slaughter process. But it may not be necessary that those pigs suffer. It may be necessary if one is raising poultry for eggs, that the eggs be regularly taken away from chickens, ducks, or what have you. But it's not necessary that those chickens or ducks live in cages so small that they can't turn around, or so cramped that they begin to peck each other to death. When we look at sufficient food or water, or deprivation of necessary sustenance, or failure to provide minimum care, for neglect, again, those have different implicit meanings. Failing to provide a minimum care in Oregon extends to not only food, water, and shelter, but also basic veterinary care. Whereas we don't see the same implication for veterinary care in all of their states. Depriving an animal of something is different, arguably, than failing to provide an animal with that level of care. So as we dig into the statutes in a particular state, we may find that there are both explicit and implicit loopholes that speak to what kind of behavior is criminal and what kind of behavior, therefore, can be enforced. And this brings us to a discussion of what kind of conduct we're actually talking about. And it's important to realize that when we talk about cruelty in terms of the law, in terms of animal cruelty, in terms of criminal law, we don't mean that word in the way we usually mean it when we talk about it. We don't mean it in the way we discuss it in the vernacular. We don't mean something unpleasant or brutal or causes suffering. We don't mean something that is uncomfortable. We simply mean behavior that meets the legal standard of cruelty. So to flip back, again, in some states that would be unjustifiable pain. In some states that would be unnecessary suffering. So what we're talking about when we talk about applying animal cruelty law in a farming situation is unlawful conduct. And I assure you that conduct is implicated and can be enforced. And this applies not only to general animal cruelty, but also farm-associated animal cruelty. And farm-associated animal cruelty is usually what we think of. This would be cruelty that often arises from, particularly in an industrial agriculture context, an emphasis on efficiency, making money, and erasing individual identity. So this is looking at animals not as individual sentient beings, but as interplaceable widgets, units of commerce, and thinking of death and suffering as the cost of doing business. This also means that systemic cruelty doesn't get an automatic pass. Just because something happens, because that's how the agricultural system is meant to work, doesn't necessarily mean that conduct is beyond the reach of the law. If an animal is subject to criminal cruelty because that is easy or is efficient, that doesn't necessarily make it legal. And cruelty law can still be used to reach and intervene with that behavior. Criminal law can also be used to reach and intervene with particularly egregious behavior. Finally, it's important to note that criminal law protects farmed animals from what we would think of as general cruelty. And we don't often think of this as being something that farmed animals face. We don't necessarily think of farmed animals as being implicated in animal sexual abuse, as being implicated in animal fighting, is in being implicated in the use of animals as means to leverage domestic violence victims, or being implicated in hoarding situations. But I assure you, I have seen all of those scenarios happen with farmed animals. Humans are capable of great kindness. We are capable of doing heroic work on behalf of animals and each other. We are also capable of brutality to each other and to animals. And simply by virtue of being a farmed animal does not put an animal beyond the scope of that conduct. And so when we think about farmed animals, it's important to realize that a farmed animal that's being neglected or being cruelly and abusively treated may be being treated that way because someone's making money by cutting corners. It may be being treated that way because someone is frustrated and trying to move the animal more quickly through a factory farming environment. The animal may be treating that, he or she, the animal may be treated that way because someone is saying to a family member, if you don't do as I say, I will starve your horse. I will not feed your cows or your chicken, as a leverage of control in a domestic violence scenario. An animal may be abused because in order to gratify the perpetrator's sexual appetites. An animal may be neglected because the animal is being hoarded, and simply because the animal is a horse or a duck or a chicken, an animal that we often think of as coming in a herd or a flock, doesn't mean that hoarding pathology cannot apply, and it doesn't mean that that animal shouldn't be protected and isn't protected under animal cruelty law. So, what are some reasons that it's hard to see these laws enforced, and what can we do about it? So there's some challenges to additional intervention. One is these practices are often hidden. They happen behind barn doors, behind slaughterhouse doors, and in fields away from the public eye. There's a lack of knowledge in law enforcement circles and prosecution circles regarding what animal needs are, and in particular those of farmed animals. People may intuitively have an idea how cats or dogs should be treated, but they may have no idea what horses or goats need in order to meet the legal threshold for minimum care. And finally, there are logistical issues. If one is a member of law enforcement in a cash-strapped rural county with a small staff, it can be daunting to realize that you need to seize 300 head of cattle. You will say to yourself, where do I put these neglected cattle? Some of these neglected cattle are pregnant. I will have baby cows to deal with. My local municipal animal shelter has no place to put baby cows, much less sick, neglected cows that need to be nursed back to health. This will cost a lot of money. What do I do? Can I enforce this law? At the prosecutorial level, there are challenges involving their statutes. What is good animal husbandry? What is necessary or justified suffering? There are issues regarding mens rea, that is a mental state. When did a perpetrator act recklessly? Is leaving your herd of cattle out in the winter reckless if it isn't snowing at the time? If you know that occasionally blizzards happen that would freeze those animals dead, but there isn't a blizzard happening right now, is it reckless to leave those animals there? And if a blizzard does occur and those animals die, can you be prosecuted? There are occasionally complex legal regimes with interlocking levels of statute and regulation, and there are concerns regarding juror sentiment. There's often a worry that jurors will not convict people of treating farmed animals cruelly because they will feel differently about farmed animals versus companion animals, versus animals that live in their own homes. And there are general challenges related to notice and due process. Particularly around some of these vague terms, there are fundamental justice issues that are implicated if someone just decides that something that has been legal for a century in a particular jurisdiction is now illegal without anyone being put on notice. And all of these overlapping areas can be pretty confusing. You may feel like this confused calf that you see before you. But the good news is, you do not need to be confused. And in fact, this is no confused calf. This is bat cow. If you're not familiar with bat cow, I encourage you to look further into that. Bat cow is a delightful member of the DC superhero universe. But there are answers to all of these issues. One of the things that's important to remember is just because an issue involves animals doesn't mean it's beyond the normal scope of criminal practice. We can use a lot of our traditional time-tested tools for dealing with criminal conduct and enforcing criminal law and apply them to farmed animal cruelty. So if we have a hard time figuring out what's happening in a place that crime occurs, we can get eyewitnesses, we can get informants. If we have a hard time knowing how an animal died or the way an animal suffered, that's what forensics veterinarians are for. We can get those individuals to testify, to say, based on this animal's corpse, the animal didn't die because he was sick. This animal died because he was starved. We can get a veterinarian to say, based on the condition of this horse, she was experiencing suffering and not the kind of suffering that was necessary, not the kind of suffering that was unavoidable. If one is worried about jurors, among other things, that's what jury selection, voir dire, is for, but also we can contextualize matters for jurors. There's a large difference we found between jurors being asked to look at lawful behavior, reasonable behavior, and unlawful behavior. And jurors generally are not fans of people taking advantage of animal cruelty law in order to harm animals or in order to shave fractions of a penny off the cost of animal commerce. There are also animal-specific techniques that can be deployed. For large animal seizure, prosecutors and law enforcement can rely on something called seize in place. Normally when animals are seized, the government takes them and removes them to a government shelter where they will be provided with care and assistance, or transfers them to a volunteer shelter. If that isn't possible because the animals are themselves large or because there are a lot of those animals, they can be seized where they are. That means the government takes over the responsibility for providing them with care, food, shelter, veterinary assistance, but the government is allowed to go to the place where they are, and the perpetrator, the defendant, is not allowed to interact with those animals. So you can leave the herd on the pasture where the herd has been found. You can leave the flock in the building where the flock has been located, but you can bring in the resources those animals need to get food, shelter, and care. We can turn, in some jurisdictions, to specialized prosecutors who have the knowledge and expertise to deal with these issues as a matter of course. For example, in Virginia, there's a animal prosecution unit housed within the state attorney general's office, and they do excellent work involving farmed animal issues. In Oregon, there's a statewide animal cruelty prosecutor who will travel to any county in the state and prosecute animal crimes. And he has done a number of farmed animal cases. And finally, realize that much like that cow can turn to crypto, a superdog, you don't have to do this alone. You can work with government agencies that have expertise. You can work with state and federal agencies. And you can work with nonprofits. And one of those is, of course, the Animal Legal Defense Fund. We are producing farmed animal prosecution guides for every state in the nation. We've got 2 of them in hard copy. The 3rd is coming out shortly. And we're making these available to prosecutors in each state in both hard copy and electronic form, so that if you're a prosecutor and you're trying to figure out, is this cruelty and what can I do about it, you can quickly find out the answer. This walks you through what the law is and what the basic procedures you need to enforce that law from investigation all the way through to post-sentence. Also myself, my colleagues here in the Animal Legal Defense Fund's Criminal Justice Program, one of the things we do is provide assistance to law enforcement, prosecutors on these issues, both at a trial level, and we also file amicus briefs on behalf of the animals involved and their interests at the appellate level. And we are eager to get involved in all of these cases. And I'll make sure to give you my email address at the end of the presentation if that becomes relevant to you further on. So, I want to run through some selected case law, both because these are good jumping off points if you're interested in using the law. These are good points if you're interested in learning more about the law. And these illustrate that when we work on farmed animal cruelty issues, we not only improve the law for farmed animals, but we build better case law for all animals. We create precedent that is good for individual farmed animals, good for farmed animals as a category, and good for all animals. So to briefly run through some of these, we have State v. Schott out of Nebraska. And this is actually the example I gave you involving cows left out in the winter. This was an area that was known to get extremely cold temperatures. Cows were known to freeze to death during the winter. And the defendant, Mr. Schott, left his herd of cows out. And indeed, a number of them froze to death. They died unpleasantly, they died slowly, and he was prosecuted for animal cruelty. And his defense was, wasn't snowing when I left them out there. There was no guarantee it would snow. You can't prove that I had the right mental state, that I was criminally reckless in leaving my cows outside. And ultimately, as this went up on appeal, the state of Nebraska found that, yeah, if you know that it's going to snow, if you know that you're living in a place where it gets cold enough for animals left outside without sufficient shelter to suffer and die, and you leave animals in that condition, that is criminal recklessness. And your conviction, given that the jury found that you engaged in criminal recklessness, is legitimate. Westfall versus State out of Texas is a good reminder that the plain view doctrine, the doctrine that you don't need a search warrant to deal with something that law enforcement officers can see from a legitimate vantage point in plain view, applies to fenced fields. If you could see farmed animals in a field from, for example, an open road or from a neighboring property that you have permission to be on as a law enforcement officer, and you can see that those animals are most probably suffering a criminal level of abuse or neglect, that is sufficient to generate probable cause. You have legitimate reason to view those animals. State v. Fessenden out of Oregon asks whether there's a warrant exception for animals in crisis. There's a deep dive on case law involving this. Again, I can go there if you want, but the takeaway is that it stands for the proposition that at least in Oregon, if an animal is suffering unlawful treatment that is resulting in ongoing serious harm that represents a imminent danger to the animal, law enforcement can intervene, can seize that animal, can get the animal the immediate help the animal needs without a search warrant. This is more limited than the kind of exception you would get for a human in Oregon, but it's a significant recognition of the animal's need for protection and the animal as its own being, its own actor that deserves to be dealt with as such. State versus Nix out of Oregon tells us that animals are crime victims for sentencing purposes. This is the you don't get to abuse one, get the rest free rule. Most crimes at some point in the analysis of prosecuting the case, of charging the case, end up asking whether multiple victims were harmed. And if so, there's a separate charge or a separate sentence for each of these victims. This is why if someone goes into a convenience store and walks out with a 6-pack of beer, a handful of candy bars without paying, they only get charged with one count of theft because they might have stolen multiple items, but they only stole from one victim. Whereas if they stole candy bars from one store and a six-pack of beer from another, that would be two victims, two sentences, or two charges. State v. Nix stands for the proposition that even if a person abuses multiple of their own animals, they don't get to reduce that down to one sentence or one charge. It's one charge for each animal, for each victim. And again, this is an important recognition that the animals count. And beyond that, an important recognition that animals count as something that is not an object, that animals can be crime victims, and that animal cruelty law fundamentally exists to keep those animals safe. Crime victim is a particularly legal category. It's a distinct legal status. And the fact that animals are, at least in some ways, able to reach that underscores that the law does not treat animals as property, or rather does not treat animals as objects. It does treat them as property, but that is a more nuanced issue than we are often led to believe. That simply being property doesn't mean that animals don't have legally enforceable interests, doesn't mean that animals don't have, if you want to call those legally enforceable interests rights, doesn't mean they don't have rights. Animals have the legally enforceable interest not to be subject to unlawful cruelty. In that context, animals have the right not to be subject to unlawful cruelty because animals are not objects. Animals are feeling, sentient creatures. And that tees up the final case I'll note here, Justice versus Bircher, which is being brought by my colleagues in the Animal Legal Defense Fund Civil Division, that fundamentally asks whether an animal crime victim has the ability to sue their abuser for compensation for the damages that abuser caused. The animal in question, the horse you can see at the bottom here, has suffered ongoing and permanent medical harm by being subject to criminal neglect that his former owner has pled guilty to. If he was a human who had been subject to this neglect, he'd be able to sue for medical costs, for future damages. And the question now is, can he do that? Is the only thing that stops him from doing that the fact that Justice is a horse? I know I'm running short on time and I want to get to your questions. So let me briefly run through some closely related legal issues, talk about what you can do, and then we'll get to addressing that red I want to talk to you like that I see going on. So a few related but non-criminal issues that come up. Ag-gag laws, where within Upton Sinclair's Ghost, that is the author of The Jungle, would like a word, a number of state lawmakers. Ag-gag laws are designed to do one thing, and that is prevent the public from knowing what goes on inside animal agriculture facilities. And this can happen a variety of ways. It can be a prohibition on recording the inside of animal agriculture facilities. It can be a prohibition on whistleblowing. It can be a requirement that people who become aware of crimes within those facilities aren't allowed to continue in gathering information, but they have to immediately report to law enforcement before there's an opportunity for them to figure out exactly what is going on. The good news is there is a coalition of legal forces led by, again, the Animal Legal Defense Fund that is tackling this predominantly as a First Amendment and a equal protection issue, and has been thus far largely successful in pushing back those laws. There are a variety of environmental law implications. For example, factory farms. We talk about the farm part, but we also should look at the factory part. And much like non-farm factories, they result in farm-type pollution. As you can see in the cartoon here, which is actually a political cartoon from a pro-hog farming outfit, but one that is concerned about the impact of large industrial farms on small family farmers. Large farms produce an incredible amount of waste, and that waste has to go somewhere. And traditionally, what is done with that waste is not that it is treated, not that it is rendered harmless, but it is collected in large pools, which are referred to as lagoons because that is more palatable than a pool of pig poo. And they are then typically sprayed on neighboring fields, or they run off into the water supply. Typically, this involves polluting and negatively impacting places where impoverished people live, individuals who tend to be, given the dynamics of these communities, given the dynamics of our country and our country's history, people who are marginalized by virtue of their ethnicity, their indigenous status, or their class. And finally, there's a whole range of advertising and labeling law issues, where within companies either try to humane wash their products, putting labels on their product that are meant to cause consumers to think they are buying a cage-free egg or a humanely slaughtered animal, or an animal that was raised in a free-range environment, when in reality, that may not be the case. Or laws that are being passed to try to prevent plant-based, that is non-animal-based products such as tofurkey or soy milk or almond milk from calling themselves milk, or calling themselves tofurkey chicken or tofurkey sausage, what have you. Missouri is currently at the forefront of this, and again, my colleagues in the Civil Division are part of a coalition headed up by Tofurkey as the lead plaintiff who are challenging that. So what can we do? And then we'll have 20 minutes of questions. As legal practitioners, the main thing I would encourage you to do is, regardless of your field, regardless of whether you're working in criminal law or otherwise, consider the animal experience and an animal's interests in your practice. I assure you that animals intersect with your practice in ways that you may not have considered or anticipated. And you can begin to do animal law just by asking, what is the animal's stake in this? For those of you doing criminal work, law enforcement or prosecution, or hopefully in the near future, those of you in a position to apply animal victim representation to farmed animals, the techniques I mentioned earlier are going to be relevant to you. We can get you specific assistance for individual cases, but the overall takeaway is to absorb and apply sound animal case strategies. And some of this involves using techniques that would be intuitive in a non-animal situation. So for example, if you're drafting a search warrant for animal cruelty in a farming context, don't just draft your warrant to address the animals, draft it to address everything that speaks to that cruelty. You want your warrant to cover the animals, to cover the bodies of dead animals, to cover unborn animals, to cover veterinary records that speak to whether the animals have or have not been receiving required care. You want records that you want your warrant to cover available veterinary medicine on site. If you are a law enforcement officer serving that warrant and seizing animals, your instinct may be to get the animals out of there as quickly as possible because those animals are suffering. And I applaud you for that instinct, but I'm going to ask you, please don't do that. Videotape and catalog everything on that scene. You want every animal to have an identification number. You want every animal to be tracked in terms of where it came from on the scene, and you want video or photo of where it came from. Because your prosecutor, in order to prosecute this case, is going to need to be able to show which of the 100 sheep was neglected versus which of the 100 sheep was abused. Which of the cattle was subject to abuse 1 versus which of the chickens was subject to neglect in the 2nd degree. And so we'll need to connect individual animals to individual placements and treatment and context. For non-legal animal professionals, please encourage your field to come up with clear, relevant, applicable standards and policies. So for example, if you are a representative of a group that could actually speak to what humane practices are, it probably behooves you to know what they are, to have a standard, and to say that in a forthright way, and to encourage your members to do the right thing vis-a-vis your animal charges. For example, in Kentucky currently, it is illegal for veterinarians to report animal cruelty. It's the only state in the country where that's the case. And that has put the American Veterinary Association in a difficult position in terms of figuring out what to advise their members to do. If you're a member of the AVMA, I would encourage you to come up with a policy and pressure your organization to come up with a policy that takes into account the legal needs of your members in Kentucky, but also the needs of animals in every other state where it is continuing to be legal to report cruelty. For everyone, legal professionals and non-legal professionals, we can push for change. We can look at legislative scorecards and see what lawmakers are creating better laws for animals, and we can hold our officials accountable. If we want law enforcement officers who enforce these laws, if we want prosecutors who prosecute these cases, we can vote for people who do that. That's the system working the way it is supposed to. But that means we have to let those individuals know that we care about animal cases and that we're going to vote accordingly. The good news here is that most of those positions occur at a county or state level. And each of you as individuals has a much greater voice there than you do at the federal level. County and state officials don't hear very often from their constituents, and definitely don't hear from them very often around farmed animal issues and issues of animal cruelty. So if this matters, if you want to see an enforcement and change, contact your officials and tell them this matters to you. Tell them that you understand that certain behaviors are legal and you're not asking them to enforce the law further than they legally can, but you are asking them to enforce the law as written. Or if they're lawmakers, that you want them to pass better laws. And finally, we can all learn and we can all live what we've learned. Educate yourself, make choices accordingly, and remember that it's important to take care of yourself as you do that, and take care of others, including animals. And I put this last piece in here because it's easy, I've found, when we talk about the needs of animals, we talk about trying to change the law, for us to strive for perfection. And we have a saying in the law that the perfect is the enemy of the good. And I think that's really relevant here. It's easy when we're trying to be perfect and holding ourselves and others to a standard of perfection to burn out, to become cynical, to become bitter. And what I would say is that particularly in the law, especially in a common law system where we advance by building precedent and moving forward one imperfect case at a time, perfection is not our game. Perfection, if you'll forgive the metaphor, perfection is the domain of gods and monsters. Our role is to deal with what is imperfect. Our role is to, as attorneys, accept that we have to deal with imperfection and still try to make things better, still strive for justice. We aren't gods. Law school, I'm sure, convinced you of that. We aren't monsters, no matter what lawyer jokes may have you believe. What we have to do is be willing to deal with imperfection and make the system more just on behalf of everyone, animals included. And I would argue that being willing to embrace that imperfection, being willing to slog through that difficult terrain, that makes you a hero. So my closing thought for you would be, don't worry about perfection. You're not a god, you're not a monster. Go be a hero and be a hero for animals. And with that, I'd like to answer any questions that you might have.
That was beautiful, David. I really like that. Thank you so much. I definitely learned a lot. That was a lot of information, but you spelled it out very, very well. No clarification needed. So
Great.
we'll get through we'll get through as many questions as we can. So to start it off, Melissa's wondering, what's the average duration for transport? 28 hours seems like a very long time. How far are these animals usually going in total?
So that's a good question. And I don't know of a database that gives us all of that information. I know that there are efforts currently afoot to try to find and correlate all of that. But 28 hours is a long time. And it's important to realize, as always, certain animals are going to be exempted. So poultry, for example, they don't even get the 28 or more hour break. But that 28 hours was put in place in theory to allow animals to at least get off a truck, get off a train, stretch their legs, get some water, relieve themselves, not literally on the heads of the animals around them. In practice, animals need to use the bathroom more than every 28 hours, and they're often on those conveyances for more like 30, 36 hours.
Oh, thank you. Annette asks, actually, sorry, Jenna, let's do this one first. Jenna asks, during floods and other natural disasters, which we're definitely seeing a lot more of, pigs in farms often drown, as well as other animals. Do they have any protections during this time? Is there a heightened protection in that? I know that in North Carolina, the last hurricane that happened, you saw those images of the pigs on top of the roofs. So
yeah, and those were heartbreaking images, both because of the pigs, not only the ones on the roofs, but the ones that didn't make it to the roof, and also because those lagoons of pig poo, they don't stay put during those floods. So it's had awful impacts on those animals and on everyone in the community, both animals and wildlife. To answer your question, there's no heightened protection in terms of cruelty law. The question at that point really is, at what point does allowing your animals to suffer and die as a result of catastrophes becomes so predictable that not having an alternate plan in place reaches the level of criminal negligence or criminal recklessness. And we aren't there yet for floods or hurricanes. But as climate change continues, my suspicion is that there will be areas of the country where it's increasingly hard to argue that no one could have seen this coming. 100-year floods are going to become 5-year floods, are going to become every year floods. And at that point, you just can't argue that it isn't reckless to put animals in that position.
absolutely. Jennifer is wondering, so for the farm animal prosecution guides, which states are available, and are you able to get those publicly, or do you need to request them?
So currently we have Illinois and Florida. Those are the two we've got available right now. We are in the process of dealing with some more, and I can tell you which they are as soon as they're done. We should be rolling out the next one, hopefully next few weeks, and then we've got 2 more starting production. We're trying to limit those to law enforcement and prosecutors for a variety of strategic reasons. If nothing else, it's generally good form to try to make sure that the people that we are helping build their cases are not giving the people that are perpetrating these crimes the same degree of insight into what you have to build a case. But we could potentially make that available to people doing related work. If you're curious, please get in touch with us, and we'll probably have to take it on a case-by-case, individual by individual basis, but we'll see what we can do.
Perfect, thank you. Loretta asks, could there ever be a law that forbids political candidates from using hunts and rodeos as fundraisers? For example, Senator Inhofe used the pigeon shoots as fundraisers. Not sure if he still does, but I believe many congressmen and senators have used pigeon and gopher hunts as political fundraisers. That's an interesting, I hadn't considered that.
It's exciting for so many reasons. It's timely, it involves farming and hunting, and it involves free speech. So many things. So what you've raised is That would be a great law review article. Someone out there is listening to this and thinking, I need to write a law review article. Or for those of you law students who are looking for a paper to round out your experience. But a short answer is going to be this. Hunting is legal in most states. In the same way that there's an exception for farming, there are exceptions for hunting. The only place off the top of my head where that's not going to be the case is Washington, D.C. So the hunt itself is not going to be illegal, assuming it's happening in whatever ways fit that exception. And the next question is, can you make that political activity illegal? That's going to be really tough to reach, because you're talking about saying to a political candidate, you can't do this otherwise legal thing because you want it to be a political act, because you want to enhance your candidacy, because you want to raise your profile with voters. My suspicion is the court is going to look at that and say, you are fundamentally infringing on the free speech, the political speech of that individual, and you're doing it in a way that picks out them from a different kind of restriction than anyone else. And so that's probably going to fail on a number of free speech grounds.
And Loretta did follow up and say that these were, at least for Senator Inhofe, and I'm not sure if I'm pronouncing that name correctly, so forgive me, but I guess they were caged raised pigeons, and so there were issues of legality there. But like you said, very fascinating topic.
Yeah.
It would be very interesting to see an article exploring the possibilities with doing something like that, and then the pushback as well.
Well, it's certainly canned hunting. So the raising of animals in captivity and then releasing them to be hunted, whether it's anything from pigeons to lions, tigers, that's something states can make illegal. Even if you're in a state that has a right to hunt law, that doesn't mean that people have the right to hunt any animal they want, any time they want, any way they want. So that's certainly something that could be prohibited.
Yeah. Caitlin is asking, how successful have right to farm laws been to prevent implementing or improving protections for farmed animals?
Right to farm laws are troublesome. And one of the reasons they're troublesome from an animal law protection standpoint is they encapsulate and embody a lot of these exemptions. So when you're trying to deal with those implicit and explicit carve-outs, it's one thing for them to exist at an implicit level, another thing for them to exist at an explicit level, and then it's a whole nother level when they exist in a state's constitution. When a state says as a constitutional matter, you have a right to farm, and then the question becomes to farm in what way? Is this to farm in traditional ways, to farm using good animal husbandry and so forth? So I can't give you a global answer. I can say that it has made it difficult to implement animal protection laws for individual animals. It also makes it difficult to deal with the larger impact of farms in terms of environmental impact and nuisance impact on neighbors. And it in many ways is a strange carve out for that particular industry. Farming is a business. It's an industry like many others. It gets a very particular set of protections that not every other kind of worker or industry receives.
I think we have time for one more question, and Holland is asking, would you care to comment on the right to rescue movement?
Well, it's a very broad question. So yes, I'll be happy to do that. I will preface this by saying that right to rescue means a lot of different things to a lot of different people. And I do not know what exactly you mean. So I will first describe what I think is a fairly general way to talk about right to rescue, and then I can give you my thoughts on that. So right to rescue often refers to the attempt to build a legal argument that would say that when someone becomes aware of an animal suffering, there is a legal right to intervene and rescue that animal. And the question is going to be, is that suffering limited to unlawful suffering? Does the animal have to be suffering criminally? Or is it any kind of suffering? And then who gets to intervene and rescue? This is distinct from open rescue, which is a whole different issue. be happy to talk about that too, but we're running out of time. So right to rescue is a great idea. It requires some care in terms of how we draft rescue laws. And I think it's going to require some clever litigation for people who are trying to get that in place without a law. So we've already talked about one right to rescue, in effect. When we were talking about State versus Fessenden, fundamentally what that case stands for is the right of a law enforcement officer to intervene and rescue an animal facing imminent criminal harm from the conditions of that harm. That could be extended by case law to say an officer can intervene even when the animal isn't being subject to criminal harm, if an animal is just facing imminent harm of any kind. There are states that have passed laws allowing citizens to intervene in certain circumstances. These are often, for example, known as dog and hot car laws, although they are rarely restricted to dogs. So if you see an animal in a hot car, and you'd have to check your state law. So before you go intervening and rescuing animals and saying, David told you to do that, check your state law or Google ALDF hot dogs and hot cars. We have a whole website. But there are laws that allow regular citizens, regular civilians, regular individuals, non-law enforcement folks to intervene and rescue animals from that kind of situation. As for farming contexts, it's going to depend on those kinds of laws. Is there a law that says when you become aware of an animal in need, can you rescue that animal? Do you have to be law enforcement? Do you have to be a Humane Society agent? Does the animal have to be unlawfully treated? Is it any kind of harm? And finally, is that a matter of statute or is that a matter of case law? If it's a matter of statute, it's easy to find out, relatively easy to find out whether you can do it or not. You can look up the statute, you can retain an attorney to give you advice. If it's a matter of case law, probably what needs to happen, and probably what I would suggest the right to rescue movement ultimately is looking to tee up in states that don't have a statutory basis for this, is what we traditionally call a lesser of two evils defense. The notion that while taking that animal out of there might be unlawful because you're taking someone's property and removing it, the law doesn't like that, but also leaving the animal there to suffer would be bad. And if you're faced between doing two bad things, particularly two unlawful bad things, the law generally prefers that you do the less bad one. And so I think the right to rescue movement is looking for a good test case. And that test case is probably unlawful cruelty, where preventing that unlawful cruelty requires some minor unlawful act. And I know there are attorneys and movements out there looking for that case. We'll see what happens when it turns out.
Well, thank you so much, David. I'm getting so much feedback already about how much people have learned today, and I know I did. As always, with these webinars, they're so fascinating. And just thank you so much for taking the time and to educate all of us and to leave us with such an inspiring motivation to go out and be heroes for animals, because I really do believe that all of us can, whether you're an attorney, an advocate, student, any way that you can incorporate that into your life and your communities and your circle is just amazing. So thank you so much. Any last parting words?
I would just echo what you said. I think that especially given the ubiquity of how animals interact with our lives, and farmed animals are present in all areas of commerce and modern life, we can all find ways to have an impact. And remember, especially at a state and county level, your voice is much louder than you think. You see up on the screen in August, my colleague Kelsey is going to do a talk on some of those advertising issues that I alluded to. It should be really fun. I recommend you check it out. I'm looking forward to tuning into it. And thank you very much. I really appreciate it. And even though I didn't get to see you, I've seen that red feedback light going off, and I appreciate all of your time. Thank you.
Yes, thank you everyone so much for joining us and being so interactive and having such great questions. After this webinar ends, there is a survey. I really, really ask that you take that. It helps us so much with our future plannings. And yeah, we hope to see you back on August 6th with Kelsey talking about false advertising and consumer protection helping animals. So see you then, and until enjoy your summer, and I hope that everything is going well. Thank you so much, David, again. And this recording will be available, so please share it with family, friends, colleagues, anyone you think who might be interested. Thanks, and until next time.
Thank you.